And now, Professor Raul Pangalangan, Honorable Justice Hari Kumar Nair, Justice Pang Kang Chao, Justice Alex Wong, Deputy Attorney General Lionel Yee, Jones Day Partner, Mr. Kai Yanes Wegner, His Excellency Medardo G. Macaraig, Ambassador Extraordinary and Plenipotentiary of the Embassy of the Republic of the Philippines in Singapore, distinguished guests, ladies and gentlemen, on behalf of the Center for Asian Legal Studies, thank you for joining us today for the Stephen Brogan-Jones Day Legal Fellowship Lecture on the Rule of Law. Do international courts matter? International law and governance in a turbulent time. And to begin today's program, I would like to welcome Associate Professor Jacqueline Nyo, Director of CALS, to give her introduction. Professor Nyo, please.
Good evening, honorable judges, ambassador, colleagues, students, and friends. Welcome to today's lecture by our very first Stephen Brogan-Jones Day Legal Fellow on the Rule of Law. Thank you especially for braving the rain to be here. Established in 2022, the fellowship was endowed by the Jones Day Foundation to honor its managing partner, Stephen Brogan, who has been known as a tireless advocate for the rule of law. Now, as part of the fellowship, leading judges, practitioners, and academics spend time at NUS Law in our center to conduct research and deliver a lecture or a seminar on critical issues impacting the rule of law in Singapore and across the world. Now, I recall that at the launch of this fellowship, guest of honor, Murali Pillai, Senior Counsel, now Senior Minister of State at the Ministry of Law and Transport, noting that Singapore is a steadfast champion of the rule of law. He further expressed hope that this fellowship would help address pressing challenges in our region and reaffirm the rule of law as a cornerstone of peace, stability, and progress. Now, I'm sure SMS Murali probably could not have envisaged how prescient his remarks were as we face multiple global threats to peace, stability, and progress today. What was then a statement of principle, well, just 4 years ago, seemed even more critical today. As we witness mounting strains on the international order, international rule of law, rising geopolitical tensions, fracturing norms, and increasing skepticism towards multilateral institutions, some might say that international law and international courts might be facing an existential crisis. And in such an environment, the rule of law has to be upheld, not merely as an ideal, but as a necessity. And it is in this context, today's lecture is especially timely. And we are very privileged to have Judge and Professor Raul Pangalangan with us, and his insights on international courts come at a moment when these issues could not be more pressing. So I very much look forward to Judge Pangalangan's lecture and his engagement with Dr. Nilüfer Oral, Director of the Center for International Law, who will be chairing the Q&A session later. But for now, let me pass the floor to Mr. Kai Yanes Wegner, partner at Jones Day, who will be speaking on behalf of Jones Day and Jones Day Foundation, and to let him introduce our speaker today. Thank you.
Your Excellency, Mr. Deputy Attorney General, distinguished guests, justices, colleagues and friends, good evening. It's my privilege to welcome you on behalf of Jones Day to this lecture. As you heard, is named after Steve Brogan, who was for about 2 decades the managing partner of Jones Day and has been throughout his career a champion of the rule of law. And I think that brings us to the speaker this evening, Judge Pangalangan, who served as the judge of the International Criminal Court in The Hague from 2015 to 2021. And he sat on some of the most difficult cases of our times, including cases relating to war crimes and attacks on cultural and religious heritage. Before that, he was the dean at the University of the Philippines College of Law, where he remains a professor emeritus. He holds an LLM and an SJD from Harvard, where he received both the Leyland Prize and the Charles Summer Prize. He's a member of the Permanent Court of the Arbitration at The Hague. He's also a member of the Institut de Droit International, and he has lectured at the Hague Academy of International Law, where he also served as a director of the studies. Tonight he asks us a question, as you already heard, which cannot be more timely: do international courts matter? And I think few voices would be better placed to answer that. Justice Pangalangan, thank you very much for being with us this evening. I think the floor is yours.
To the distinguished guests here present, to my hosts at the National University of Singapore, ladies and gentlemen, welcome. As has been expressed by Professor Neo, I'm so glad that you're here present today despite the weather. I thank the Center for Asian Legal Studies for making it possible for me to speak here today and to experience and enjoy the intellectual community here at NUS. You know, until this trip, I had visited NUS many times just for conferences. And it is because of this fellowship, the Stephen Brogan-Jones Day Legal Fellowship, that made it possible for me to immerse myself in the intellectual community here. So to Professor Jacqueline Neo, thank you. Thank you so much for inviting me. And I thank you for all the support of the center and its staff. Maraming salamat. For a Filipino to speak on international law here in Singapore, I feel I should start with an obscure case. This is our national hero, Jose Rizal, the leading intellectual of the anti-colonial revolution. Well, he was arrested in Spain as a dissident. He was being brought back to Manila. He was eventually executed by firing squad, and the place where he was executed remains kilometer zero for the Philippines, the spot from where we measure all distances in the Philippines. But what people don't know is that 2 months before his execution, he was actually in Singapore. And there was a desperate plea for habeas corpus, asking the Supreme Court of the Straits Settlements to rule upon the legality of Rizal. And the decision was made by the Chief Justice then, Lionel Cox. And if you look at some of the briefing documents, it shows that it was actually resolved on the basis of international law, and that they weighed, both sides of the argument. That he wasn't on a naval vessel; it was a commercial boat. But at the same time, the boat was shipping some Spanish troops who were being brought to Manila to fight the rebellion, which had erupted by then. But then eventually the Chief Justice declined to issue the writ of habeas corpus. Which brings me to the central point of my presentation today, which is the place of courts, the place of rules, vis-a-vis these big events. And you see, one can speculate on what might have happened in Philippine history if Rizal had continued on in Manila. He was an intellectual, one of the moderates, and with his execution, basically the more militant, comrades in arms of Rizal took over. Of course, on the other side, people say that maybe things moved forward when the doers took over from the thinkers. But we can speculate forever on what might have happened. But the important thing is that submitting to adjudication requires a certain mindset. And my favorite quote is from US Supreme Court Justice Benjamin Cardozo. He wrote about the nature of the judicial power, and he was speaking about the US Bill of Rights, but he spoke about the assaults of opportunism, the expediency of the passing hour, the erosion of small encroachments, the scorn and derision of those who have no patience with general principles. That, in fact, is what we struggle against if we deal with international law from the standpoint of the courts. My presentation then will divide it just into on three major themes. I will begin with an event that happened in February 2022, because for me, it is like 4 years ago, but at this stage, the international law responses to the Russian invasion of Ukraine are already clear, they're in place, and I will use that episode to reflect on international law issues coming from our part of the world, from the ASEAN, and to look at the barriers to jurisdiction. And I will, in fact, find common themes, which, for me, common issues that arise in the nature of judicial power. And then I will conclude with, on a more positive note, on what I call solidarity filings at various international forums where states have been more active in asserting international law. Let me proceed then with the international law measures to deal with the Russian invasion of Ukraine. I compare the responses of three institutions. So this is the ICJ, International Court of Justice, which hears cases on the responsibility of states. Over there is my former court, the International Criminal Court, which deals with the individual criminal responsibility of people charged with various crimes that I will discuss later. And below is the UN in New York. Let me start with just a general picture. The point here, and there are dates, is that the global community did try to respond as fast as possible to the February 24 invasion of Ukraine. And you will notice from the dates here that, for a discipline, public international law, which typically moves at a glacial pace, like the tectonic movements, this is actually lightning speed for international law. And for me, the most critical is, especially my former court, to start with the February 26 filing before the ICJ, the March 2 declaration of the prosecutor, Karim Khan, that he was going to open an investigation on the ICC. But notice too that after that flurry of activities, the next events were already more than 1 year later. The issuance of the warrant of arrest of March 17, 2023. In other words, you can say, critics of the court can say, if that's your idea of fast, it's not, you're not capable of dealing with these emergencies. And the February 2 decision 2 years later by the ICJ just on jurisdiction. So again, I point this out so that when I speak about the contribution of international courts today, we have a realistic sense about the time frame. They can move fast on certain matters, but on the major of the landmarks of the case, it does take a while. But let me then deal with the other changes that are embedded in the procedural regime that we choose. We begin with the most political. This is the UN the UN General Assembly. The votes on the wall there show their votes on their resolution condemning the invasion. And these are the norms that they invoked. As candidly as possible, it was an invasion by Russia, and therefore they invoke the settled rule against the use of force under Article 2, Paragraph 4 of the UN Charter, and the rules under Chapter 7, which says that, you can have recourse to war only if there is only in self-defense. Also, the settled definition of aggression in the authoritative UN General Assembly resolution. Again, this is a political forum. So as you can imagine, it was blocked by Russia with its veto in the UN Security Council, but the UN General Assembly invoked an old resolution from the Korean War in the 1950s, saying that, well, if there's a stalemate at the Security Council, we can take action on, action meaning adopt a resolution, and this was the resolution they adopted. Notice, at this stage, it is still a candid condemnation of aggression. And the next procedural regimes that you will look at, you will witness the whittling down of the norm. Now we proceed to the ICJ. You will recall this is about the responsibility of states. So if the court can act on a dispute, it will have to establish its jurisdiction on either of these grounds. Either the voluntary submission by both parties, or the submission through treaties and conventions. I have a summary in the next slide. Or the third is compulsory jurisdiction. So these are the short terms. The first is by special agreement. The second is a compromissory clause in treaties, where states sign up for the treaty and says, if there's a dispute under any clause of the treaty among the states parties, we go to the ICJ. And the third is compulsory jurisdiction, an advance submission to the court. So just to point out, so Ukraine and Russia are not submitting by mutual agreement in the compromise. So that strikes out the top. You can strike off the bottom because they have not submitted to the compulsory jurisdiction of the court. So the only chance to sue Russia is via a compromissory clause in the treaty. So if you were the lawyer assigned to find a way to file the case, you will go around, you're sniffing around for a treaty that both Ukraine and Russia have signed and which has a dispute resolution clause. They found one, the Genocide Convention. Disputes between the contracting parties, et cetera, shall be submitted to the ICJ. That was the jurisdictional anchor for the case of Ukraine against Russia. But notice, if the cause of action is genocide, typically it will be Ukraine saying to the court, Your Honors, can you stop those Russians from committing genocide against us? But that wasn't the case. They had to be rather creative in saying that their case falls under the Geneva Convention. And that is why they said it is a right not to be subject to a false claim of genocide. So, this is rather unusual, rather too creative, but the fact is, for the purpose of the court, it fell under the dispute resolution clause. And but notice, if you look at the situation between Ukraine and Russia, if the compromissory clause refers to a dispute between the contracting parties, and you see all these pictures, you will say, well, of course they have a dispute. One country has invaded the other, it's bombing the other, destruction of civilian homes. This is a playground. Of course there is a dispute. But lo and behold, Russia says there was no dispute because it had to be a dispute about the Genocide Convention. And the court says, well, it is enough for us that you disagree on whether there is genocide being committed. In other words, it is as if the court did not see the bombing and saw the words. And they said, well, If one side says there's genocide and the other side says there's not, well, you have a dispute. And that triggers off the compromissory clause, and therefore we have jurisdiction. And that was the conclusion of the court. Now look at the way the cause of action will morph yet another time when we move to my former court, the International Criminal Court. So it is a court established to try the most serious crimes of international concern. It will be complementary to national jurisdiction. It is a court of last resort. And so, if from the UN General Assembly, they characterize it already as aggression, and aggression is within the jurisdiction of the ICC, one would assume, oh, finally, we've got the court which can actually rule on aggression. And then the prosecutor says, and this is a quote from him, he says, well, I can investigate any crime, war crimes, crimes against humanity, but not aggression, because I've got jurisdictional rules to deal with. The jurisdictional regime says that for this very heavy crime, tracing back to the Nuremberg Tribunal, to the Tokyo War Crimes Tribunal, both sides have to be parties to the statute, and that requirement is not satisfied here. And so the court says we can move only on war crimes and crimes against humanity because there is an ad hoc submission by Ukraine, and there is a territorial nexus of crimes committed in the territory of Ukraine. So again, notice, it is almost like a lawyer's game of trying to make the problem fit into the jurisdiction of the court. But that wasn't the last. 1 year later, the court issues a warrant of arrest against Putin. And if you read the newspapers, they rejoice. They said, ICC has issued a warrant against Putin. But it wasn't for aggression, quite obviously. It wasn't even for war crimes. It was for kidnapping the kids. Now, of course, this is a serious crime. I mean, I'm not trying to belittle the warrant of arrest. But you see, for all the things that have been raised in that case, they had to narrow it down to the most specific of the offenses committed by Putin. And that is why the initial warrant of arrest was against Putin and against his cabinet secretary in charge of social work, of children. So, we now face these issues, barriers to jurisdiction. How does one frame a dispute into a judicially manageable case? How do we make history fit into the courtroom? And these are the threshold issues. Jurisdiction ratione persone, on which state has a standing to file the case, which state can be made to answer, and ratione materiae, what international issue can be raised before the court. And I will now look at them in relation to cases in our part of the world. I will leave you to read them because I'll go individually through these cases. Just note, the most important at this stage is the basis of jurisdiction. It's compulsory jurisdiction in the first, Cambodia and Thailand, compulsory jurisdiction, Portugal and Australia, but for Pulau Ligitan, Pulau Sipadan, it is a special agreement. For Singapore and Malaysia, it was by special agreement. And for Gambia and Myanmar, it is the compromissory clause in the Geneva Convention. In preparation for this lecture, I read two very interesting books. One is both by two experts who taught at NUS Law School, Professor Jaya and Ambassador Tommy. And the first book is Pedra Branca, and the second is The Unheard Cases. I just spoke to Justice Pang earlier that his picture is there in the book. He was part of Singapore's team. Also, Lionel Yi is. I hope I'm not missing any names, but those are. I recognized them as soon as I opened the book. But notice special agreement, that is the joint submission by two parties, is the safest basis for jurisdiction. But if you look at the negotiation leading to the filing of the case over Pedra Branca, I better recite the Middle Rocks and South Ledge. They faced similar problems that the Philippines faced in the filing of the case against China, on the South China Sea case. The question of what maritime features will be submitted to the court. I have to be careful, the lawyers are here, so please correct me if I'm missing any point or if we have to finesse any point. But I understand that the Singaporean position is that all three features have to be submitted, and that there was some initial issue of whether Middle Rocks and Middle Rocks and South Ledge would be excluded from the case. In the Philippines versus China case, the big issue was whether to exclude Itu Aba, the largest of the maritime features from the case. I don't think I'm violating any confidence because it was typical of the Philippines, debated publicly. But just to show that these are problems that are faced even when parties have already resolved to submit the dispute, amicably before a court. And for me, the fact, for instance, that the Philippines agonized over that issue on Itu Aba, initially my sense was, this isn't good. But when I saw that even Singapore and Malaysia had to, debate the issue earlier, it was quite assuring for me to see that, these are legitimate issues that parties face when they frame a case before a court. The other, which was submitted to by joint submission by the parties, was between Malaysia and Indonesia on two islands there. And Pulau Sipadan, I think it is famous as a scuba diving destination, and Aligitan, which is not inhabited. And I have another slide. But again, I emphasize the fact that it was submitted by joint submission by the parties was the strongest basis for jurisdiction. Now, a case dating back from '62, which was revived more recently, is, and of course, there's a conflict raging there now, is the Temple of Preah Vihear. It was Cambodia who won the case. Thailand has construed the award as narrowly as possible, and it has led Dean Simon Chesterman to speak of the ICJ's decision as an exercise in judicial modesty, because the court, in order to resolve the case, decided it as narrowly as possible. That the decision was simply on the temple itself, the promontory where the temple was located, and categorically said that we are not called upon to interpret the entire boundary on the basis of that treaty. So there is yet another aspect of judicializing a dispute. That is the tendency to reduce the issue to the barest minimum that can be subjected to judicial power. Let me now move to the genocide against the Rohingya in Myanmar. A case was filed in the ICJ. It was Aung San Suu Kyi who defended Myanmar. in the genocide case. But notice the petitioner was the Gambia. And the basis of jurisdiction was, familiar to us by now, the Genocide Convention. Likewise, the Dispute Resolution Clause. The argument, one of the arguments anyway, of Aung San Suu Kyi was, well, I can see that there can be a question of genocide here, but we don't have a dispute with the Gambia. Because she says, if you look at the map, we are over here, this is Myanmar, and the Gambia is over there on the other side of the map. It's not even named in the big map. You have to make it smaller to see the Gambia is right there, a sliver on the rightmost side of the map. So she says, if the dispute resolution clause requires a dispute, it should be a dispute between us and those guys far away. And she says, we never quarreled with them. In much the same way that Russia was telling Ukraine, well, sure, we're bombing you, but we don't disagree with you on anything about the Genocide Convention. So, but anyway, the ICJ rejected the case, said that it has affirmed its jurisdiction. But notice the next transformation. When it moved to the ICC for individual criminal responsibility, the word genocide has vanished. For the simple reason that Myanmar is not a member of the Rome Statute. The genocide allegedly was committed in Myanmar. Bangladesh is a signatory to the Rome Statute. And there is the crime of deportation and persecution. And as you're familiar in criminal law, that crime is consummated as soon as they cross over into Bangladesh. Again, put yourselves in the shoes of Bangladesh. They say, hey, we see our name there being investigated. Just to remind you, we are the good guys in this problem. We are taking in the refugees. Through a sliver of land there, on the border, the common border of Bangladesh and Myanmar. And but the court had to authorize an investigation solely on the crime of persecution, but not of genocide. Well, the last complication is this. The prosecutor has asked for a warrant of arrest for a person who at that time was the highest ranking general. Well, 11 days ago, he was elected president. So now you have to deal with the next issue of head of state immunity, which again, under the Rome Statute, is waived by all states parties, except that Myanmar is not a state party. So just to show you, these are the layers of complications that we encounter along the way. Let me now proceed to the next case. This is an old case. But in a way, this old case anticipates a trend that has emerged. At that time, East Timor, Timor-Leste today, was under the military occupation of Indonesia. And people were, in international law, people were saying, well, maybe a case should be filed on this. And then lo and behold, Portugal files a case, not against Indonesia, but against Australia. So the same thing over a treaty that Australia signed with Indonesia over the Timor Gap, over the resources between those two territories. And this time, both Portugal and Australia were under the compulsory jurisdiction of the ICJ. And the effect of that basis of jurisdiction is that the parties having in advance submitted to jurisdiction, well, they were like, the metaphor is they're all sitting ducks if they are sued. And Portugal says to Australia, well, if you sign an agreement with Indonesia over the resources of East Timor, then you are recognizing, you are validating their military occupation of East Timor in violation of the right to self-determination of the people of East Timor. And Portugal says, well, just like the Gambia vis-a-vis Myanmar, Portugal says, well, we're so far away, but the right to self-determination is erga omnes, a right owed to the world, and that therefore can be asserted by states other than the directly injured party. And, but notice the wording of the Australian objection. The case is artificially limited to the question of the lawfulness of Australia's conduct. And the true respondent is Indonesia and not Australia. So notice, what I earlier called a creative formulation of the cause of action, here is called the artificially limited question. Well, the court agreed with Australia. The court says, well, on one hand, Portugal is right. The right to self-determination is erga omnes. Of course, we all have a stake in asserting the right when the right to self-determination is violated. But we cannot resolve this dispute without acquiring jurisdiction over Indonesia. And Indonesia is not within our jurisdiction here, and therefore we cannot decide the case. Let me now proceed to the next one. My next two cases will involve the Philippines. My ambassador is here, so I better make sure that my ambassador will not object to any of my presentations. The Philippines filed a case against the People's Republic of China as an arbitration under the auspices of the Permanent Court of Arbitration at The Hague. And this is from the website. And notice, the source of jurisdiction is the compromissory clause under the Convention on the Law of the Sea. And well, this is the general clause under the UN Charter. And judicial settlement and arbitration is part of the Pacific settlements of disputes. This is the contested area. That is I will say, the usual map of the South China Sea. And this is the 9-dash line by which that China claims is part of its territory. This is the compromissory clause that was invoked. So, any dispute between the parties concerning the interpretation and application of this convention. And the others are the arbitral procedure and the identification of an arbitral tribunal under the law of the sea. So that provides the framework. But this photograph is rather telling. This is held in the grand hearing room of the International Court of Justice. That's the back of our foreign minister, our Secretary of Foreign Affairs, Alberto del Rosario, and the Chinese side is empty. They refuse to take part in the proceedings. We engaged foreign counsel, reading the books by Professor Jaya and Ambassador Tommy. I understand that for Singapore also, in the Pedra Branca case, that the engagement of counsel was a deliberate decision, as it was for the Philippines. Just to make sure that I cover the ground, China issued a position paper rejecting jurisdiction. And they took part only up to I won't even say took part, but they made the submission only for the jurisdictional part. And this is verbatim from their position paper. Notice the first. Again, it is very similar to Australia's objection in Portugal's case on East Timor, where it says, hey, you pretend that all that is at stake here are your maritime claims under the Law of the Sea Convention. And they say, no, it is really a fight over territorial sovereignty, over those contested features. And therefore, if your basis for jurisdiction is the Law of the Sea Convention, this doesn't fall under that because it's about claims of territory over land, not over water. They also said that, well, we actually signed the declaration already on the South China Sea. This is the ASEAN plus China agreement, saying that we should talk about these things through negotiations, not through litigation. And also that when China signed up for the dispute resolution clause, they excluded maritime delimitation, which is correct. Well, the court said that, well, the court is not pronouncing itself on any claim of sovereignty over land. In other words, the plea by the Philippines was phrased mainly, purely as a claim over water and solely under the Law of the Sea Convention. On the Declaration on the Conduct of Parties, the court says, we have looked at the declaration. It is a political statement. It does not give rise to legal obligations. And on the third point, the court said there is no maritime delimitation here, and indeed the pleadings of the Philippines was careful to do that. And the court proceeded to hear the case in accordance with the rules on non-appearance of parties, and this was the conclusion. The court merely characterized the maritime features. None of them were recognized as islands capable of sustaining human habitation and therefore capable of generating an economic zone. Tribunal does not determine sovereignty. I've mentioned that already on the declaration of conduct. And the 9-dash line has no basis under the UNCLOS, and no historic titles arise under the UNCLOS. I will go back to these points in a while. This is my last case. We're back to my former court, the ICC, and the case of former President Rodrigo Duterte. He's now in jail. Well, his daughter is our vice president. But the father was arrested in March of last year, so there has been a falling out between the incumbent president and the incumbent vice president. But he's accused of murder as the founder and head of the Davao Death Squad. And so these are just pictures of the killings of small-time drug users. They didn't target the drug lords. And that is why the deaths are typically in the slums. In fact, some people say, if the target are actually drug users, how come not a single drug user was arrested in the fancy residential villages of Manila? And they're all in the slum areas. The Rome Statute is founded on the principle of complementarity. And it is there, the last line, to put an end to impunity. The fact that no Philippine court was moving despite the thousands of deaths. And despite the thousands of killings, he remained popular. Well, I must warn you, the next slides, Duterte was given to a lot of profanity. So there will be some. This is Duterte, with his favorite expression. He called Obama the son of a whore. He took on Obama, he took on the Pope, and then he took on God. Of course, nowadays there's another fellow who loves to debate with the Pope. But at least with Duterte, he doesn't have all these images depicting him as Jesus or something. But despite that, Duterte continued with the killings, and he withdrew from the Rome Statute. These are headlines from Philippine papers, and well, now he has been arrested. And tomorrow, in fact, the court will issue its decision on jurisdiction. So we are actually in suspense out there in Manila. But his argument is complementarity. He says that if you're a court of last resort, don't try me in The Hague. I must be tried in Manila. And the basis is the clause on complementarity and the requirement of admissibility. And the test is this, that the court steps in only if, in this case, the Philippines is unwilling or unable genuinely to carry out the prosecution. Now, there are lots of debates on what it means to be unwilling or unable genuinely to prosecute. But the numbers really are terrible. There are at least officially, by the government's own records, at least 6,000 deaths. They have prosecuted 8 people. 8 out of 6,000, by any measure, is unwilling or unable genuinely to prosecute. But for me, you don't even have to go to the numbers. For me, the best proof of being unwilling genuinely to prosecute is this citation from the Integrated Bar of the Philippines. It is the Law Association of the Philippines. Given to Duterte for 50 years of distinguished and dedicated service, upholding the ideals of justice, integrity, the rule of law, unwavering commitment, invaluable contributions as a pillar of inspiration to the legal community. Big words. But for me, the most telling is the date. It is September 2025. The guy was in jail already, God's sakes. And and the lawyers got together and voted to give him an award. If that is not unwilling or unable to prosecute, I don't know what is. So, by way of conclusion, these are the patterns that I'd like to point out. The increasing cases of what I call the non-Hofeldian plaintiffs. This is a term from American constitutional law. The non-Hofeldian plaintiff is a litigant who is not actually directly injured. He is there to vindicate a public claim. And Portugal, the Gambia, and South Africa have nothing to do. Well, they don't have skin in the game, so to speak, in the actual crisis and atrocities that are being litigated. And yet they file a case to vindicate that claim. So it requires, on one hand, the willingness of the non-Hofeldian plaintiff to grant them standing, and to recognize the erga omnes quality of the obligation itself. That is the first. The second is what I call solidarity filings. And this is the basis for the solidarity filing, the intervention. When a state, two states are fighting, and the third state says, hey, I think I have an interest of a legal nature which might be affected by the decision. And so look at the interventions. 34 states in Ukraine, 6 for Gambia, 22 in South Africa versus Israel. I mean, that is quite significant. Compare that to, and this is not really a shining moment for my country, we tried to intervene in Pulau Sipadan and Pulau Ligitan, and we were denied. We were not allowed to intervene, but we were the solitary intervener there. We would have had more company if it happened a bit, closer to this time. So we have first the solidarity filings at the ICJ, and then the increased participation in the advisory jurisdiction of the court, because the ICJ is, unique in that its charter allows it to issue advisory opinions upon request by authorized international organizations. And look at the numbers. states voluntarily appear before the ICJ, give their statements, and therefore contribute to the decision. The third are solidarity filings at the ICC. You see, when Russia invaded Ukraine, the prosecutor said, well, I can proceed to investigate this case, but I need permission first from a pretrial chamber. But he said, it will move faster if I have a state referral by a member state. He said that, and then within 1 week, he had actually 44 today, but within 1 week he had 34 state referrals. All he needed was one. And for Palestine, he had 8 referrals. That is a legal measure to jumpstart the proceedings. And the last is the war of diplomatic notes. This is relating to the South China Sea. You know, it was actually triggered off, but by what I would have thought was an innocuous filing by Malaysia. And before we knew it, there was a flurry of notes verbal flying back and forth. In fact, if you look at the record, sometimes one state will issue a note verbal in the morning, and after lunch, there will be a reply from someone else. And this is a quick rundown of the notes verbal, but let me just give you a sampling. This is Malaysia, this is China, and this is the Philippines. Malaysia invoking the Convention and the Law of the Sea. China saying we consistently oppose that submission by Malaysia, that arbitral award is null and void, has no binding force, and of course, the Philippines saying the opposite. But I would like just to point out 3. This is the US version. You know, the US hasn't signed the Law of the Sea Convention. So it says, inconsistent with international law as reflected in that treaty that we haven't signed. And therefore, invoking the award, the arbitral award against China. This is Australia, invoking the conclusions of the arbitral award. And this is Vietnam, invoking the legal reasoning reflected in the award. You know, these are nuances, but it shows for me, the fact that they make the effort to make these nuances shows the importance of the forum where these statements are being made. And so this is my last slide. There's an increasing recourse to international courts, increasing participation by non-Hohfeldian plaintiffs, asserting erga omnes obligations. Well, I would call it the creative framing of cases to meet jurisdictional constraints, prospects for joint submissions via special agreement, expanded recourse to advisory jurisdiction, and a call for a return to first principles in this era of gunboat diplomacy. You know, it is said that, it has been said that when the whole world is mad, 'tis folly to be sane. And that is how I feel when I watch the news these days. And I feel that sometimes talking international law is either a desperate effort, to carve out a zone of sobriety and sanity, or maybe a desperate statement of hope that there can be, that there can be the triumph of conscience in these difficult times. Thank you.